So now let's talk about access to records. There's been some discussion on the IACP Police Psychological Services section listserv in this past week about access to applicant records. And I guess you can't read that when I do it that way, can you? Sorry. Okay, so one that's often cited as justification for blocking an applicant's access to records is an intelligent decision by the Department of Central Management Services in Illinois, Roulette versus Department of Central Management Services. This is a 1986 case, and the Illinois Appeals Court found that the psychologist's written evaluation of a police applicant's test scores and interview notes with applicants were exempt from disclosure under Illinois Freedom of Information Act. And many have relied upon this case in the 25 years since then to justify blocking an applicant's access to the data and to the report. I'm not sure you're going to be as successful today. I think in many ways, you should. I like blocking applicants' access to the psychological assessment data. I just don't know that in every jurisdiction you can count on that. And I think there's good reason to believe that you can't in many jurisdictions. In Nevada, for example, an applicant is absolutely entitled to full access to their pre-employment psychological evaluation. You cannot prohibit it in the state of Nevada. It's a Supreme Court decision. Now that isn't true in every jurisdiction. So they range from one jurisdiction to another. You need to know what's true in yours. But let's look at some cases that might be help you better understand the range of court decisions on this question. In Stamford versus Freedom of Information Commission, the Connecticut court dismissed the City of Stamford's administrative appeal from a decision of the commission that ordered that a rejected police applicant be provided with their psychological evaluation, but said that you could delete the test questions. So, need to give the person access, but you can delete the test questions. In Schroeder versus Detroit, the Michigan Appeals Court held that public interest in disclosure of the evaluation under the Freedom of Information Act was outweighed by public interest in non-disclosure. But it's worth noting that in this particular case, the court reached the decision after noting that the city had already provided the plaintiff with a detailed explanation of the results of the psychological evaluation and concluded that the applicant was entitled to an explanation, but that the information already given them was sufficient to apprise the plaintiff of the defendant's reasons for denying him employment and to determine the reasonableness of the defendant's administration of the evaluation. In other words, the court believed that the applicant was entitled to understanding how you reached that decision and to be able, as a result of that knowledge, to determine whether or not it was reasonable. So just saying, sorry, you don't get anything, may not work in your jurisdiction. It's going to depend upon state law, it's going to depend upon other case law.
So even if it's in a release that says, that they signed in the beginning, that says you will not have access.
Yeah, that's saying that you will not have access in your release is a declaration of your belief about it. Whether or not the court agrees with you is a whole nother no, it's not, it doesn't, just because you say you're not going to have access to it, the court may go, yeah, well, watch this. Right. In Patton versus the FBI, the federal court upheld the FBI's refusal to release portions of a rejected applicant's application. But that was federal, and it may not be the same in your state. Now, that's under the theory or under the statute of FOIA, Freedom of Information Act. Things go differently when you use different statutes. Let's use HIPAA as an example. Now, Pettis v. Cole is not HIPAA, but it is the Confidential Medical Information Act, which is a state counterpart to HIPAA in California. What did Pettis v. Cole do that is so relevant to California psychologists?
Said too much.
It defined a examinee in a psychiatric evaluation as a patient. In an employer, in a compulsory examination compelled by the employer, the examinee was defined, and the relationship between the examinee and the examiner was defined as patient-doctor relationship. So when we say, as we often do in our disclosure and informed consent documents, we have no doctor-patient relationship,
We're lying.
that's not true. We are lying about that. In California, it's absolutely not the case. You do have a doctor-patient relationship. It's not a treatment relationship, but let's look at what some other courts have said about it. Cleghorn versus Hess. The Nevada Supreme Court held that individuals examined by a psychologist to determine their suitability for employment are patients within the meaning of a statute requiring health care providers to make patient records available upon request. Therefore, if you are examined by a psychologist in the state of Nevada for purposes of employment and you request your records, you must be given them.
Wow.
No exception is carved out by the legislature for police or other public safety applicants. In Valentin versus Boots, a New Jersey case, a New Jersey court ordered that the pre-employment and fitness for duty evaluations of a police officer are not protected by privilege and are discoverable to a citizen plaintiff who brought suit against the officer and the police department. I think it's noteworthy, though, that the court did limit disclosure only to the records provided by the psychologist to the employer. In other words, the employer only had to release the records they received. Thus, Portland Police Bureau's refusal to accept any reports. The applicant requests the report from them, they're going to have to give it. If the plaintiff subpoenas it, they're likely going to have to give it, plaintiff's attorney. But if I have it and they've never received it, they're entitled to it. But they're only entitled to that which I communicate to them.
But then wouldn't they go after you?
Pardon me?
Then wouldn't the applicant go to you?
Oh, they could go to me, but then what I would say is I can't communicate anything because you're not my client, except it's under court order. And then their attorney is going to work hard to block it, and they've always been successful so far in being able to block it because they don't have it. In McGrill versus Ostrup, Seventh Circuit case, you all know Eric Ostrup, great guy, very competent psychologist, board certified in forensic psychology, good friend to all of us, I think. And, but as in Pettis v. Cole, the court held in the Seventh Circuit that McGrill, who you may recall is a police officer compelled to submit to a fitness for duty examination, was, under the law, a recipient of mental health services provided by Eric, and enjoyed the rights of confidentiality associated with personal health information, including the right to prevent disclosure of intimate and irrelevant details of his history. So the report really needs to be very careful and circumspect in what kind of detail you provide.
I'm confused. And wasn't it Pettis where that says we don't provide details, right? Just
That you don't provide, Pettis did say that you don't provide that kind of detail.
But what keeps that officer's attorney from subpoenaing my records? I didn't provide, oh, if I didn't write it. Yeah, it just subpoenas my notes.
He can subpoena your notes, whether or not, and of course, you're going to contact, in the case of a subpoena, you're going to contact your client, which will be the agency. And you're going to give them an opportunity to try to suppress that,
Okay.
to try to fight that subpoena. And they'll work it out. Whatever the court tells you to do, you do. See, I don't have a dog in that hunt. It doesn't matter to me. If they want my records, they can have my records. It's not my fight. I really don't care. I don't ever get heartburn over the release of records because I don't do anything without the court mandating it or without giving the opportunity to the person who owns those records to dispute it. Now, if they don't and they just ignore it, then I'm gonna provide the records, I got a subpoena.